And without further ado, we are continuing with our next presenter, Mr. Ciril Ribičič. Professor Ciril Ribičič is an emeritus professor at the Faculty of Law at University of Ljubljana, a former judge of the Constitutional Court of the Republic of Slovenia, and a former member of the European Commission for Democracy Through Law, the so-called Venice Commission. He is a great expert in constitutional law, human rights law, and also electoral law. Professor Ribičič will introduce us a very interesting topic regarding the elections in Slovenia and gender equality. He will present the amendments to the Constitution of the Republic of Slovenia in 2004 and continue his presentation by presenting European standards on women's equality. Council of Europe, the Venice Commission, European Union, and also his presentation will follow with a critique of the interpretation and application of the Constitution and legislation that maintains men's dominance or predominance in politics. So his presentation will also show us a possible interpretative decision of the Constitutional Court that would prevent such practice de lege ferenda. Mr. Ciril Ribičič, please, the floor is yours.
Thank you very much for your kind words. I would like to thank especially colleague Alenka Antloga for the invitation and wish you all a successful conference. A man advocating for women broader inclusion in representative and executive authorities encounter mistrust and ignorance among women and rejection and ridicule among politicians. I will try again though. I believe that women are not to blame themselves, but in Slovene politics, they are neglected against their will and contrary to general social interest. Consequently, they also cannot be solely held responsible for their situation does not improve. The male majority controlling the politics at the local and national level is the first to be called upon to achieve a more proportional representation of women and men for society benefit as a whole and its coordinated action. This is all the more important in a crisis in which society should not afford to give up the activities and influence of half the population. Opposition to more equal participation of women and in representative bodies would be more convincing if the prevailing men's policy were more successful and enjoyed broader trust in the public and among voters than it enjoys today in Slovenia and I suppose in other European countries too. The story of women representation in 100 years ago not start promising with the Article 70 of the Widow Down Constitution stipulated that women's right to vote shall be determined by law. The fundamental problem was not that such an important issue was degraded from the constitutional to the legal level, but in fact that the law had not been enacted until World War II, and women were left without the right to vote. It was not until World War II that more courageous solutions to this issue appeared within the liberation movement. Women are afforded the right to vote at the establishment of liberation and field committees at the age of 18. In case they carried weapons, the age census was even lower. Something similar was brought about by the introduction of workers' self-management in the 1950s, when workers acquired universal suffrage at the age of 18, and by the age of 15, all employees were able to elect work councils. It's known that socialist Yugoslavia has a respectable constitutional judiciary and constitutional law science, thanks to which the European Conference of Constitutional Courts in Dubrovnik was established in 1972. It's less known that the constitutional courts of the former republics have also functioned since the mid-1960s. This was also the case in Slovenia, where this fact is obscured by those who imagine the constitutional judiciary kicked off only with them. When I served as a constitutional judge in 2004, at the celebration of the 40th anniversary of the Constitutional Court of Macedonia, one of colleagues reminded me of the activist decision according to which Slovenian Constitutional Court was famous, and I will summarize this decision below. After the public hearing, the Constitutional Court of Slovenia, by decisions from 1977, annulled the provision of internal legal acts, 10 units of the well-known Celje enterprise EMO, insofar as they gave preference to male candidates over women in the systematization of jobs. The annulment decision is based on the constitutional principle of equality between men and women, which must also be respected when competing for jobs in the economy. Therefore, in the Constitutional Court opinion, it was unconstitutional to give preference to men when running for a particular positions. The court adjudicated that the only exception could be those particularly dangerous jobs that were detrimental to health and which women were not allowed to perform because of their biological characteristic and motherhood. Today, such a decision is self-evident. Of course, at the time, it significantly impacted the equal employment of women in Slovenia and other parts of former Yugoslavia. Following the adoption of this decision, companies abandoned the hitherto broadly established practice of privileging male candidates, both in their internal legal acts and public vacancies. Otherwise, they would have risked the annulment of their decision. This demonstrated the actual de facto erga omnes effect of the Constitutional Court decision. Of particular importance to the topic under discussion is the provisions of Article 3 of the current Constitution, which defines Slovenia as the state of all its citizens. In the Constitutional Commission, I personally insisted the female form of the noun citizen to be mentioned first before the male form. And I have to prevent some attempts to edit the text to return the male form to where they belong, men first. My argument was that women who make up most of the Slovene population are still a neglected minority when making authoritative decisions. 20 years ago, when I tried to illustrate this feature of Slovene politics in some article, I stressed that a woman in Slovenia has never served as a president of the republic or prime minister, president of parliament, president of constitutional court, rector of the Ljubljana University, or ombudsperson. Later, Alenka Bratušek became the prime minister, Dragica Vedan Lukic and Jadranka Sovdat became presidents of the Constitutional Court, Andreja Kocijančič served as the university rector, and the ombudsperson were consecutively Zdenka Čebašek-Travnik and Vlasta Nussdorfer. This demonstrates some progress, but the representation of women in state and local representative bodies has remained low and is in constant flux from election to All of us who strive for more participation of women in Slovene politics have had high hopes since the 2004 amendment to the Constitution. At the time, Article 43, which deals with the right to vote, was amended as follows. The law shall provide measures for encouraging the equal opportunity of men and women in standing for election to state authorities and local community authorities. The legal theory states that this provision allowed for so-called positive discrimination of women. Upon the adoption of this amendment, the Constitution argued that it was unnecessary because the introduction of women's quota could have been justified by a creative interpretation of the Constitution. However, the prevailing opinion was that the amendment of the Constitution was necessary because otherwise legal disputes could have been initiated by male candidates claiming a violation of the equality before the law. When associations seeking to strengthen the position of women in representative bodies proposed the introduction of quotas and so-called zippers, they repeatedly encounter objections that this violated equality of suffrage and discriminatory treatment of male candidates. Therefore, a proposal emerged to regulate the issue in the Constitution in such a way that it would no longer be possible to object the unconstitutionality of measures then they were to reduce the gap between the representation of men and women. The fathers of this amendment, one of them was Miran Potrč, to Article 43 of the Constitution, stressed that women in Slovenia represent 51% of the population, and their participation in public affairs has amounted to only 11 to 14% in the last 10 years. According to the National Assembly assessment, which adopted the amendment by a very large majority, this was not a discriminatory treatment of men, but a solution seeking to eliminate discrimination against women. The measure was conceived as anything but gender neutral. There is no doubt that the purpose of amending the Constitution was to improve women's position in the National Assembly, other state bodies, and local community bodies. Also, the text speaks of the promotion of equal opportunities for men and women. The amendment of the Constitution stems from the fact that women are in substantial minority in all these bodies, most notably as mayors, then in terms of representation in municipal councils, and finally in terms of representation in the State Council and the National Assembly. An interesting question is whether such a justification of the amendment to the Constitution and the text of electoral law are in conflict. Men are not underrepresented in local and state authorities. On the contrary, they dominate in all these bodies. This also applies to the National Assembly, in which the share of female decreased from 1/3 to 1/4 to 23% to be exact in the last parliamentary elections in 2018. If someone were to try to enable the introduction of male quotas by law, this should be no means successfully as the constitutional review, in my opinion. It will be so, at least, in my opinion, until the end of the 21st century. Council of Europe Gender Equality Strategy 2018-2023 speaks about specific policies and actions, including positive actions when appropriate, in critical areas for the advancement of the women, for the realization of de facto gender equality. In my opinion, the commitment of the Council of Europe and member states' governments for balancing participation of women and men by 23, 50, 50, so the balance 50-50 is far from realistic. And as long as this is the case, women quotas will be in accordance with the Constitution because they promote a more proportional representation of women in the National Assembly. In contrast, men's quotas have the opposite effect because they contribute to maintaining male dominance in Slovenian politics. In the latter case, a well-founded constitutional amendment is interpreted and applied contrary to the constitutor intent. Let me illustrate this with a concrete example. Electoral commissions annulled a list of the candidates for deputies of the National Assembly in one of the constituencies because there were too few men, less than 35%, and the courts, including the Constitutional Court and the European Court of Human Rights, rejected all legal remedies against such a decision. The effect of such a decision is all around detrimental because it has prevented the small Sloga political party from running for more women in the hope that it would have helped reduce the gap between the representation of men and women in the National Assembly. The political party has not been successful in elections. Still, if it had been successful in constituency, it could have achieved at best the election of one female deputy instead of one male deputy. Thus, the dominance of men in the National Assembly could not in no way been jeopardized. Let us break down the gender-neutral quotas as they are called and defended by the Constitutional Court into two parts: the women's quota and men's quota. It becomes clear that men's quota have no legitimacy, since in men, unlike women, it's not about protecting the right of either a minority or a vulnerable or powerless or underrepresented group. Let us look at the matter from the perspective of women candidates whose candidacy was annulled only because they were women. We can see that the gender quota was justified and used in such a way as to prevent a member of the sub-representative gender from running. If we try to uphold European democratic standard in suffrage, we will run into very serious problems. The European institutions, be they the Council of Europe bodies as a Venice Commission or the European Union, need to consider very diverse solutions in this area. Very different models of electoral system exist across Europe, which this institution recognizes as democratic. These are various models that belong to the majority, proportional, and combined system. However, in conventions and human rights catalogs, a solution could not be found that would guide us in resolving dilemmas and eliminating distortions. One provision that speaks in favor of my position, however, is to be found. This is the Article 23 of European Charter for Fundamental Rights, which clearly states that the special protection of equality between women and men is justified when specific benefit measures are in favor of the underrepresented sex. And in Slovenia, here and now, only women are underrepresented. And for the conclusion, women's rights activists argue regarding women participation can be achieved under the proportional system. Worse results are brought by the combined system and the vote under the majority electoral system.
Professor, we cannot hear you.
Yes.
Yeah,
okay.
We hear you now.
It was my fault. Women's right. Sorry. I support a combined electoral system that built on combination of majority and proportional extremes positive features. According to some logic of reducing the differences between the existing electoral systems, the combined system is suitable for today's Slovenia and promising at the global level. I believe that it's possible to find an effective way to strengthen the representation of women also within a combined two-vote system, provided that the second vote is no longer used exclusively to achieve a proportional representation of the political programs and parties, but also to maximize proportional representation of women and men. If the zipper, the high quota for the representation of women on candidate list, and the adjustment of the second vote for this purpose would not prove to be effect, I believe the adoption of legal provision ensuring a minimal share of female deputies in the National Assembly remains an option. For instance, 1/3 or 2/5 of the MPs. In my opinion, 1/3 of women representation is the minimum proportion when women no longer act in parliament as imitator of men's politics, but start working differently according to the women logic, which is more restrained, reassuring, cooperative, inclusive, and future-oriented for their children and grandchildren. Undoubtedly, this would move the effort for more equal representation of women from the candidacy process to directly interfering in how many female MPs will be elected. Thank you for your attention. I would like to say at the end that I'm speaking from Kranjska Gora, which is 5 kilometers from Planica, when the next World Championship will take place. And I have to add, the Slovenian sportspersons won 6 medals in the Oberstdorf so far. Of these, 5 medals were won by women. Thank you very much.
Thank you. Thank you very much, Professor Ribičič, for this very insightful and also very detailed presentation. The topic you have presented surely is extremely important for Slovenia, and I'm sure also beyond our borders. And unfortunately, the endeavors in the letter here in our country still remain unaddressed and are yet unmended.